In today's case, we will be addressing that affirmative action is not consistent with the 14th Amendment of the United States Constitution. May it please the Court, my name is Eva Rodriguez, along with my co-counsel Amanda. We represent petitioner in today's case of Students for Fair Admission versus University of North Carolina. My first point being that affirmative action doesn't follow the 14th Amendment, which is that everyone has to be equal. My second point being that affirmative action should be something that benefits everyone. Moving on to my first point, affirmative action is an action that lets minorities have a greater chance to get into a university even if there's a person more qualified than them. The Confrontation Clause of the 14th Amendment was made to share equality among all races. It was created to protect the people that were enslaved and make them all the same no matter their race or the color of their skin. Affirmative action, on the other hand, suggests the use of race to allow or not to allow some people into their campus or that university. The legislation enacted by Congress in the 1860s and 1870s took place because white people did not want black people or any other race to have rights, become citizens, be free, and be able to vote. The government had to put more protection for these people to be able to reach equality among them and to stop people from trying to take their rights away. The 14th Amendment addressed black codes and other discriminatory legislation by granting rights to all citizens, including those former slaves who were newly made citizens. The KKK movement of the Black Codes did not want equality for everyone. They wanted to have those privileges or those rights that no one else did. Affirmative action is one of them, but now the tables have turned. They allowed minorities to have greater chances to enter a university, but at the first time, putting down the other races of other peoples because of this action. Moving on to my first point, affirmative action is an action that lets minorities have a greater chance to get into a university, even if there's a person more qualified than them. The Confrontation Clause of the 14th Amendment was meant to share equality among all races. It was created to protect the people that were enslaved and make them all the same no matter their race or the color of their skin. Affirmative action, on the other hand, suggests the use of race to allow or to not allow some people into their campus or that university. Moving on to my first point, affirmative action is an action that lets minorities have a greater chance to get into a university, even if there's a person more qualified than them. The Confrontation Clause of the 14th Amendment was made to share equality among all races. It was created to protect the people that were enslaved and make them all the same no matter their race or the color of their skin. Affirmative action, on the other hand, suggests the use of race to allow or to not allow some people into their campus or to that university. The legislation enacted by Congress in the 1860s and 1870s took place because white people did not want black people or any other race to have rights, become citizens, be free, and be able to vote. The government had to put more protection for these people to be able to reach equality among them and to stop people from trying to take their rights away. The 14th Amendment addressed black codes and other discriminatory legislation by granting rights to all citizens, including those former slaves who were newly made citizens. The KKK movement of the Black Code did not want equality for everyone. They wanted to have those privileges or those rights that no one else did. Affirmative action is one of them, but now the tables have turned. They allow minorities to have greater chance to enter a university, but at the same time putting down other races or other people because of this action. The 14th Amendment is for the good of all races and all people, but affirmative action is not. Equality is a meaning of everyone getting the same things and no one receiving more than the other. Parents involved in community school versus Seattle School District of 2007. In this case, Seattle School District started to see race as an important factor as they were receiving applications. Although in Regents of the University of California versus Bakke, 1978 was established that race may be used in consideration, not as an important factor, otherwise this type of system is unconstitutional. In these two cases, the problem was race. The problem was that they did not see people as just people, they saw them as an ethnicity or a skin color. The 14th Amendment suggests for people to just stop looking at others as a race, but as someone that deserves the same things as them. We will never fulfill the intentions of the 14th Amendment if we don't move on from seeing everyone differently based on the color of their skin or just for being who they are. So many problems, conflicts, or and even wars have happened because of skin differences. The 14th Amendment was made after the Civil War, a war that revolved everything on race and equality. Let's not forget the true intentions of the 14th Amendment: equality and respect towards one another. Moving on to to my second point, if the 14th Amendment included privileges for Africans' descendants based they had gone through slavery or through rough times, these privileges would need to still be given to members of other races. The 14th Amendment was made for equality and not for quality. Everyone will need the same advantages or the same privileges others have. As we know, this is still a problem to this day. Minorities are still being targeted and have been victims of racism, among other stuff. This is because of the people that receive privileges and still have some sort of advantages. Affirmative action is just another way of an advantage or another way of privilege, but now for minorities. I understand that affirmative action was created to help these races that were damaged in the past. Although affirmative action also stops those races that didn't have anything to do with what happened in the past or what had happened to those races. Regents of the University of California versus Bakke, 1978. In this case, students were being rejected from universities because 16 out of 100 spots were for minorities. A student that just wants to have an education to do well in life should not be rejected just because of the color of their skin, something they didn't get to choose or have an option on. We have to understand that all races have a high, middle, and low class. This action was made because the thought of all minorities being a low class was popular, and it's somewhat true, although they forgot that not all minorities are low class. Some minorities are doing really well in life, and they are still receiving these advantages given by affirmative action, even if other people have worked harder and they deserve it more than them. Denying the right to study due to a process based on race is something that was in the past and should stay in the past. Let's go back to when racial segregation was happening in the 18th and 19th century. We all know that during this time, white people and black people were being separated, each on their own side. Even schools were part of racial segregation. A black kid could not go to a white school. Even while segregation took place, white people still had advantages for being white, one of them being that they got to sit in front of the bus for being white. The Civil Rights Act of 1964 declared this act unconstitutional while overturning the separate but equal doctrine. Affirmative action is just another way of segregation, but now it's from opposite races. Now people of color are the ones getting the advantages, the ones being in front of applications because of the color of their skin. There should not be any advantages if they won't benefit all ethnicities. Affirmative action is dividing us into sides. History tells us the effects of these separations. Let's not let history repeat itself. Now moving on to my partner Amanda with her second argument.
Hi, my name is Amanda Sanza, and I will be presenting the second half of our argument. Affirmative action is not only one of the main root causes of unsuitable workers and employees in the workforce, but it also lowers the bar for students of color. Though people of color advantages, such as being accepted into schools that they're underqualified for, consequently makes it easier to get into these schools. This creates an unlevel playing field because affirmative action favors some but not all. An example of this is illustrated in cases such as Bakke versus University of California and Greta versus Bollinger. A similarity in both these cases is that the defendants were denied access to universities that they were overqualified to be in, simply due to the fact that universities were more focused on race and ethnicity than the intelligence of those entering their school. The same privileges and rights should be granted to all students. Gender and race-based acceptances are not only unconstitutional but also unethical and unfair. Segregation and racism have been around since forever, and the damage caused to minorities can't be undone. But an equal playing field to their white classmates and equal treatment is much more important and necessary now. Secondly, affirmative action negatively affects students applying to universities and colleges by creating an unequal playing field. It favors It favors potentially underqualified students and judges based off race and ethnicity rather than academic merit. To add further context, racial preference has a negative impact on the future of these underskilled workers entering the workforce and providing a low-quality service to their jobs. This is bad for everyone as it can lead to corruption if workers don't know what to do. Expanding further on what was previously mentioned, affirmative action results in access being denied to overqualified students, once again, based solely off of race or ethnicity. Affirmative action racial preference are intended to be used to help minorities who do not have the same opportunities as others because of their race. Affirmative action racial preference are meant to be used to help Affirmative action and racial preference are meant to be used to help minorities who otherwise would not have access to the same opportunities as someone due to their race, ethnicity, etc. I believe that affirmative action provides a temporary solution to an issue that has been around for a long time. It is clearly shown that minorities have met with fewer opportunities and more challenges than white people. It has also been shown that affirmative action hasn't ended discrimination, but only enhanced the idea that someone's race has more power to enter a school than academics. Due to that fact, a more permanent solution would be changing the system. This doesn't just positively affect students, this also affects everyone. The problems found through racial preferences, unfair acceptances, unlevel playing fields, etc., could be fixed if the root of the problem was dealt with. If minorities aren't targeted in the first place, then they would not need to have help If minorities aren't targeted in the first place, they would not need an extra boost or help to have equal opportunities as white people. Affirmative action and racial preference are used now to showcase diversity and sell the idea of something rather than the actual intelligence of someone. There's one with like a zip up. Anyways, this is meant to solve the issue of unequal standing to white classmates, and for a while it was working. Now this leads to a false sense of identity, forced diversity, and negative effects on the future of the workplace. Now it is evident. I'm so sorry. I'm not focused. I'm sorry. Now it is evident. Okay. I just saw a kid walk in and he was like this. He was like.
Okay. Now it's evident.
Sorry. Now it's evident that colleges and universities want to benefit off of minorities and only accept them for their campus's homepage. The wanted appearance of diversity is unethical, especially when it is forced and leads to low-quality work and students. Universities are not worried about the intelligence levels anymore, but they're fixated on the brand or look. The idea of a diverse campus and community is more appealing because it makes more people want to apply. This also creates a false sense of identity because the people joining through affirmative action believe that they're there due to scores and applications, when really it is due to the fixation that universities have with seeming accepting. This also comes with double standards for white people joining, while, as previously mentioned, lowering standards dramatically for people of color. I believe that racial preference and affirmative action won't last forever. Eventually, we will get to the point of more diversity, which should evidently lead to more tolerance and less racism. As time goes on, race will spread, and an increase of diversity is inevitable. That being said, racism will never end, and the damage caused to these minorities will never be fully fixed. But at one point, we have to stop and realize that unless we see and through race and ethnicity, we will only continue to damage the workforce and everyone impacted by it. Additionally, Grader versus Bollinger should be overruled because it's time for a change. The Dobbs versus Jackson Women's Health Organization was overturned after a long time of being in use. Similarly, I believe that after 25 years of affirmative action negatively impacting students and the workforce, Grader should be overruled. Lastly, affirmative action is unconstitutional, which can be found in the case of Graz versus Bollinger. In this case, the overly mechanicalized system of the college was in this case, the overly mechanicalized point system the college was using was deemed unconstitutional. Brown versus Board of Education prohibited race-conscious affirmative action when it was ruled that choosing and or denying students access to public schools solely based off of race was unconstitutional. In Grutter versus Bakke, this is seen when Alan Bakke was denied his application to the University of California 2 times after saying way less qualified people of color applicants to be being accepted over him due to their race, ethnicity, etc. In conclusion, affirmative action negatively affects students applying to universities and colleges by creating an unequal playing field. It favors potentially some underqualified students and judges not by academic intelligence, but by race and ethnicity, something uncontrollable. This also has side effects in the future when these underqualified workers step into a workforce and produce low-quality work. This negatively affects everyone because without workers knowing what or how to do it can lead to corruptions. Affirmative action leads to potential overqualified students being denied purely based on race, gender, etc. We pray that the court defies Grutter and overturns affirmative action.
Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious and affirmative action?
Yes, the 14th Amendment was made for people to not treat others for the color of their skin, so it prohibits race-conscious affirmative action.
How does legislation enacted by Congress in the 1860s and 1870s affect your answer to question 1?
Affects it because it proves that the intentions are that everyone is equal and no one should have advantages.
Let's assume that the framers of the 14th Amendment conclude that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
No, because that new society is not going to have the same problems we have.
Let's assume that the framers of the 14th Amendment thought that people of African descent deserved certain race-conscious privileges due to the unique context of slavery. Would framers have argued that members of other races such as Hispanics, Asians, and Native Americans could receive similar privileges?
Yes, all of these races need the support.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
I think that they would have thought that it was not going along with the 14th Amendment.
Brown v. the Board of Education in 1954 prohibit race-conscious and affirmative action. In your answer, please address Bake and Grutter.
In this case, the overly mechanicalized point system the college was using was deemed unconstitutional. Brown versus the Board of Education prohibited race-conscious affirmative action, which was ruled that choosing and or denying students access to public schools solely based on race was unconstitutional.
In 2003, Grutter observed that 25 years after the case, the use of racial preferences will no longer be necessary to further the interests approved today. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
As time goes on, races will spread and an increase in diversity is inevitable. That being said, racism will never end, and the damage caused to these minorities will never be fully fixed. But at one point we have to stop and realize that unless we see through race and ethnicity, we will only continue to damage the workforce and everyone impacted by it.
Should Grutter v. Bollinger be overruled? Please address the Supreme Court recent discussion of stare decisis in Dobbs v. Jackson, a women's health organization.
Mrs. Bollinger should be overruled because it's time for a change. The Dobbs versus Jackson Women's Health Organization was overturned after a long time of being in use. Similarly, I believe that after 25 years of affirmative action negatively impacting students, Grutter should be overruled.
The court declines the overrule of Grutter. Can the plaintiffs prevail?
Eventually, affirmative action will not be needed. Therefore, plaintiffs will prevail. No matter what or however long it takes, we will prevail.
If the court overrules Grutter, will the military difficulty recruiting a diverse armed service?
No, race should not be an issue in the first place when applying to the military.
Thank you.